I'm Drew Stevenson, and this is a lecture for my professional responsibility class about a recent ABA formal ethics opinion number 505 that came out in May of 2023. The ABA entitles it Fees Paid in Advance for Contemplated Services. What we're really talking about here are what lawyers usually call a non-refundable retainer or advance fee. And the ABA takes a strong position in this opinion that non-refundable retainers are impermissible under the model rules. This is a little controversial because some states, in fact, allow this, and many lawyers do it. And when you're in practice, you should definitely check what the rule is in your jurisdiction. For purposes of the MPRE test or the exams in my professional responsibility course, you should go with the rule that's set forth in this opinion because that's what controls. So let's go back to our slides here and dive in. I am going to give you the big takeaway up front in case you give up on me. And I'm going to quote the opinion. An advance fee paid by a client to a lawyer for legal services to be provided in the future cannot be non-refundable. In other words, in practice, normally there's really going to be no such thing as a prepaid legal fee that's truly non-refundable to the client if the lawyer does no subsequent legal work to earn the fee. Now, if you do the work, you get to keep the fees that the client prepaid, right? Because you earned them. And that's fine. And when we talk about non-refundable, we don't mean that you have to refund the money if the client is dissatisfied with your representation or something like that. But here, what we're really talking about is you charge almost like a signing bonus, or just for agreeing to represent the client, they have to give you, it's often a few $1,000s, and then they have to pay for the actual work you do. Well, that part where they pay you just for agreeing to represent them, if you don't do any work, that's an unearned fee, and you can't charge that. You're going to have to give that back. Basically, that's our bottom line here. Now, there are three main model rules that govern legal fees. And what's nice about this opinion for students is it can kind of tie together different rules that we cover at different points in the course and make sure that you're clear on all the ethical rules about legal fees. So the main one is 1.5, which starts with talking about unreasonable fees and then has some specific rules about what types of fees you're allowed to charge in what cases and what has to be in writing and so forth. And the ABA is going to tie all these together. So it starts with 1.5 and notes that all fees must be reasonable and unearned fees must be returned to the client. So therefore, it's not accurate to label a fee non-refundable before it is actually earned, and labels do not dictate whether a fee has been earned. You may remember the model rule 1.16d requires that upon termination of the representation, a lawyer shall refund any advance payment of fee or expense that has not been earned or incurred. I cover 1.15 at the end of my course, but it's basically about how lawyers have to handle client funds when they're entrusted to the lawyer. Basically, you're going to put fees paid in advance in a client trust account. So fees paid in upfront must be deposited in a client trust account under Rule 1.15, and lawyers cannot bypass this requirement merely by labeling some or all of the upfront fee as a retainer or non-refundable. And this is going to apply to flat fees or hourly fees. So sometimes you may decide, I'll handle your DWI case or your immigration case for $10,000 or $15,000, and I want the money up front. That money goes into a client trust account until you have completed the work for the client. And if the client fires you 3 days later and you've only done a little bit of work, you're going to have to prorate the time you spent, get paid for that, and give the rest back. Sometimes lawyers represent clients on an hourly basis, but ask for money, a few $1,000s, up front, and then you're supposed to put that in a client trust account and draw against it as you do your work on the case. And if the matter ends prematurely or the representation ends prematurely, you give the rest back to the client. So let's go back here to the opinion and the ABA's discussion. The ABA notes that in the legal community today, Lawyers use lots of different terms for what we're talking about. So they'll call it an advance fee or a fee advance, special retainers or security retainers or prepaid fees. It doesn't really matter. According to the ABA, such labels cannot change the lawyer's ethical duties under the model rules. And about this word retainer, this is the word I picked up when I was a law student. It's what I always heard in practice, and it has been hard to stop using it when I teach this course. But as the ABA notes, neither the term retainer or retainer fee is found anywhere in the model rules of professional conduct. As a law student, you'd be better off just not getting in the habit of calling prepaid legal fees a retainer. The ABA says, regrettably, many lawyers use the term loosely to mean any sum of money paid to the lawyer at or near the commencement of representation. Now, historically, there was a term of art, and by historically, I mean 100 years ago or 150 years ago, a retainer referred to something very specific where it was paid and deemed earned upon the promise of availability to represent a client. Sometimes this was a situation where a client was worried that a certain lawyer who's very, very busy and in high demand wouldn't be available when they needed them, and they wanted them on call. Other times, the client wanted you to represent them exclusively so that when they call you, you could never say, I'm sorry, I'm tied up in court this week with another client, or I have a deposition for another client that day. You will always be available for them. And so this would be deemed earned already, whether the services are actually needed or requested by the client. Why? Because the lawyer is providing the service of basically being on call. And to quote the opinion, in other words, hourly time is not billed against a true general retainer in the old sense of the word, and a general retainer is not a flat fee for a specific amount of the lawyer's time. It is solely to reserve the lawyer's availability. Note that this type of general retainer, in the true sense of the word, should not be placed in a client trust account because it is deemed earned on the date of such a contract. Why? Because the client is paying you basically to be able to rely on you to be available. An archaic general retainer like this could in fact be unreasonable if it was too high or exploitative, or if it could be unearned if the lawyer does not make herself available when the time comes. So these types of true general retainers are actually very rare today, maybe non-existent. You might never come across them in modern legal practice. And here's an example they give. Let's say there's a corporate client that is in the early stages of discussions about a expected corporate merger or acquisition, and there's a certain lawyer that is very knowledgeable about this area who they are hoping to have do the legal work for it. So they hire the lawyer to be available. And then when the time comes and they actually need the lawyer says no, the lawyer's not available. And well, in that case, the lawyer has to give back the money. Other circumstances that would require a refund, even for one of these true general retainers, would be the death or disability of the lawyer, or suspension or disbarment. If the client gives you money to be available to represent them, and then you can't represent them because you've been disbarred, then you have to give the money back. And I would say the same is true if there's a pending matter and there's no expected activity on the docket anytime soon, and the client hires you in this way to be available when the case starts moving forward, and then you get disqualified from the case. You are going to have to give the money back. Now, the ABA opinion gives 3 hypothetical scenarios, which are worth talking about because they're so likely to turn into multiple choice questions either on the MPRE or on my exam. And the second one is really a minor variation on the first. So let's talk about the first one. A divorce lawyer charges a new client a non-refundable retainer of about $6,000 to cover drafting and filing the divorce complaint and any other preliminary motions or hearings or negotiations. And the lawyer says that more installments will be due after the lawyer has worked 20 hours on the matter to cover the lawyer's hourly rate of $300 an hour. and the client signs this written retainer agreement. But 3 weeks later, the client informs the lawyer that she has reconciled with her husband and doesn't want to get a divorce and would like the lawyer to return or refund any unearned fees. And let's assume, according to the ABA, that by that point, the lawyer has actually spent 5.5 hours on the case, drafting the complaint and filing it in court, and paid the court filing fee of $150 out of his own pocket. But he argues that he gets to keep the entire $6,000 because the client signed a document saying it was non-refundable. Well, according to the ABA, the lawyer owes the client a refund. The $6,000 paid by the client to the lawyer are fees paid in advance, not a general retainer. And under this agreement, the lawyer is rendering legal services at the rate of $300 per hour. And so to do some pretty straightforward arithmetic here, if the lawyer's worked 5.5 hours at $300 an hour, the lawyer has earned only $1,650 in legal fees. The lawyer is entitled to be reimbursed for the $150 they paid out of their own pocket for the court filing fee. So that means the lawyer can keep or reimburse himself for the $1,800 out of that $6,000, but has to return the rest. And failure to return the balance, which is $4,200, would be a violation of Model Rule 1.16d, which again says that upon termination of the representation, a lawyer shall refund any advance payment, a fee or expense that has not been earned or incurred. And the same is true, this is hypothetical too, even if the lawyer calls it something else, like a non-refundable engagement fee, which is, quote, deemed earned upon receipt by the lawyer. As the ABA says, there are no magic words that a lawyer can use to change what is actually an advance payment for fees into a general retainer. The hypothetical 3 is about a criminal defense attorney who charges an upfront flat fee of $15,000 that he calls non-refundable to represent a client who's facing charges, and says that the fee was earned upon when paid or earned upon receipt. But suppose that this lawyer does some preliminary work, they do the arraignment, they start drafting some motions or do some investigation on the case, but just a few weeks later, the defendant fires the lawyer before it goes to trial. Well, the lawyer, even though they charged a flat fee for the matter, they didn't really do the matter, so they have to prorate the time that they've spent, and they can be paid for that, but they have to return any fees not yet earned by doing actual legal work. I'm going to conclude with another quote from the opinion that I think clarifies this almost in property terms. When a client pays an advance to a lawyer, the lawyer takes possession but not ownership of the funds to secure payment for services that the lawyer will render to the client in the future. And that concludes our lecture about ABA Formal Ethics Opinion 505.